Good morning, Ms. Sutter.
Good morning, Your Honor. I apologize for my tardiness.
The public defender provided us a phone number that we're supposed to be able to contact whoever's on call. And is that on? Because no one answered.
It is, Your Honor. I've learned it was on silent, so I apologize. I've turned on the ringer now.
Thank you. Let's see here. Who do we have here? On the record, in the matter of the people of the state of Michigan versus Sean Egleston, file number 24-00335FY. Council appearance.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearance on behalf of Mr. Egleston for today's arraignment.
Okay, Mr. Egleston, I actually have another file for you, but we'll start with this one. This file is a felony file. And it alleges that on or about December 31st, 2023, at the area of 127 East Mason Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of assault with intent to do great bodily harm, less than murder or by strangulation. It alleges that you did make an assault upon a Jerry Egleston by strangulation or suffocation, and this was done contrary to Michigan Compiled Law 750.84. That's a felony. The maximum penalty is 10 years or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. There is, however, a habitual offender fourth offense notice. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about August 11th, 1996, he was convicted of the offense of assault with intent to do great bodily harm or strangulation in violation of MCL 750.84, and that he was convicted of the offense of domestic violence, third offense in violation of MCL 750814 on March 8th, 2007 in the 6th Circuit Court for Oakland County, and that on or about August 30th, 2017, he was convicted of the offense of breaking and entering a motor vehicle with damage in violation of MCL 750.35683 in the 30th Circuit Court, Ingham County, State of Michigan, and therefore defendant is subject to the penalties provided by MCL 769.12. That would enhance count 1 to the maximum penalty of life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. I also have people of the state of Michigan versus Sean Egleston, file number 24-02376 FY. And in this matter, I have another felony complaint. This one alleges that on or about March 20th, 2024 at 1905 West Miller Road, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of domestic violence, and that you did make an assault or assault and battery upon a Janice Moulton, an individual with whom you had a dating relationship, and that this was done contrary to MCL 750.812. This is a misdemeanor normally, maximum penalty 93 days and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. However, this was charged with a third offense notice indicating, take notice that the defendant was previously convicted of assaulting and battering his or her spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his or her household, or of knowingly assaulting a pregnant person by violating MCL 750.812 on or about October 16, 2020, and by violating MCL 750.812 on or about March 8th, 07. and upon conviction will be subject to the enhanced sentence under MCL 750.815. That would enhance count 1 to a felony, 5 years and or $5,000 in fines. There again is an habitual offender fourth offense notice that enhances this domestic violence third offense to maximum penalty of 15 years or less if the primary offense was or has a penalty of 5 years or under. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charge and the maximum sentence?
Yes, Your Honor.
Okay, in both files, you have the right to be represented by an attorney. Ms. Sutter is here to represent you today for the purposes of your arraignment on these files. You have the right to have an attorney represent you at each stage of the criminal prosecution, and you have the right to be represented by counsel if you're questioned by law enforcement. And if you cannot afford to hire an attorney, you can make a request to have the public defender's office appointed to represent you at the expense of the public. Do you understand your right to counsel?
Yes, Your Honor.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, the matter will continue all the way through to your trial. You have the right in these matters to have a preliminary examination because they're charged as felonies. You have the right to have the preliminary examination within 21 days of today's date. That's the date that you're being arraigned. And that timeline will stand unless you waive that 21 days or a court finds good cause to go beyond the 21 days to reset it. At the time of your preliminary examination, you have the right to require the prosecution to meet their burden, which is to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with these crimes. The matter proceeds beyond preliminary examination. You have the right to a trial. And you have the right to jury trial. You have the right to the presumption of innocence at your trial. So that means you're innocent until proven guilty. You have the right to remain silent at your trial and not have silence be used against you. You have the right to waive your silence and testify at your trial on your behalf. You have the right to subpoena witnesses to trial to testify for you. And you have the right to see, hear, or question any of the witnesses the prosecution calls to testify against you at your trial. Do you have any questions about any of those rights, sir?
No, Your Honor.
You're currently scheduled in both of these files for a preliminary examination and probable cause conference before me. Your probable cause conference is going to be scheduled September 13th, 2024, 8:30 in the morning before me, Judge Kristen Simmons. Your preliminary examination is going to be scheduled in both files September 20th, 2024 at 9 o'clock in the morning in person at the court before me. Did you get your notice to appear for those dates?
Yes, Your Honor.
Okay. Is he requesting court-appointed counsel?
He is, Your Honor.
Are you currently employed, sir?
Yes, Your Honor.
Where are you employed?
BPM Construction.
What's your home address?
1905 West Miller.
Is that the address of Janice Moulton?
Yes, Your Honor.
Okay, well, where are you gonna stay during the pendency of this case? 'Cause you can't stay there.
I'd say my boss has property in Lansing. I'd stay at.
What's the address?
I'm not exactly sure of the address. He buys houses and he flips them.
What's your phone number?
517-512-2926.
The court's gonna enter a plea of not guilty on your behalf on both files. I don't have his history printed here. You can address his bond. I was not provided his criminal history, so all I have to go off of is the habitual offender notice.
Yes, Your Honor, thank you. I did meet with him this morning. We did have a discussion regarding these charges as well as prior offenses. He did indicate to me that these the charges that lead to the habitual defender notices are the primary focus of his assault over violent criminal history. He did also advise me that he does have employment in the Lansing area. He's been employed at that position with BPM Construction for the past 11 years. And his boss is a person whom he has a good longstanding relationship with, and who is going to allow him to reside at one of his addresses within the city. I did tell Mr. Egleston this morning that he would have to provide that address to the court within 24 hours of his release. He did also advise me that he could not recall any prior failures to appear in court. He and I did discuss the no contact order that would be issued in both of these files today, and he does understand the seriousness of that order. I understand that there is some criminal history here as well as the allegations here today, Your Honor. However, I do believe with appropriate bond conditions like the no contact order and potentially a GPS tether, that he would be someone who is not a concern to the community or himself regarding danger, nor do I believe he would pose a flight risk. And I would ask the court to consider a personal recognizance bond for him so that he can continue working, Your Honor. Thank you.
Mr. Egleston, are you currently on probation or on parole?
No, Your Honor.
What I have here is 2 assaultive cases, 2 felonies at that, one being a domestic violence 3rd offense, and then an assault with intent to do great bodily harm, less than murder, or by strangulation. These are 2 separate incidences allegedly having occurred at 2 separate times and locations. Again, I don't have his criminal history, but I do have that the domestic violence, again, being charged with a 3rd offense, indicating that he has been convicted of domestic violence at least 2 other times, one being noted as recent as 2020. And then in addition to that, there's an habitual offender 4th offense notice, which indicates that he has other convictions, including a breaking and entering, again, domestic violence, and then another assault with intent to do great bodily harm, less than murder, or by strangulation. And so that enhances file number 24-02376 to a penalty of life if he's convicted. I believe that there is a threat to the public safety, and so personal recognizance bond will not be appropriate. With that being said, bond will be set in an amount of a cash surety bond. Bond is $10,000 cash surety. While out on bond, you have the following conditions. And that's on both files, sir. You have the following conditions. In file number 24-033 5FY. There's a no contact order that will be put in place for the protection of the alleged victim, Jerry Egleston, that is. You're not to be anywhere where he is, where he resides, where he works, where he goes to school, where he does his shopping, where he does his laundry, where he worships. Under no circumstances are you to be within 2,000 feet of that. And then you're also not to have contact directly or indirectly with Jerry Egleston. Do you understand that?
Yes, Your Honor.
File number ending in 2376, a no contact order will be put in place for the protection of a Janice Moten. You're not to have contact directly or indirectly with Ms. Moten, and you're not to be wherever she lives, works, goes to school, or carry on any other of her business. Do you understand that?
Yes, Your Honor.
Do you have any questions about what no direct or indirect communication means, or?
No, Your Honor.
So we're clear on that. Let me see here. 376, I think it was next. That should go here. Also, while out on bond, you're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're not to use or possess drugs or alcohol unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You need to report to pretrial services within 48 hours of your release. That's on both files, okay, sir?
Yes, Your Honor.
You have any questions about your bond conditions?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing further. Thank you.
You're all set, sir.
Your Honor, was that 10,000 per bond?
10,000 cash surety on each file.
Okay, thank you.
You're welcome.
Yeah, it's 10 each. Yeah.
On the record in the matter of the people of the state of Michigan versus DeMarion Joseph McCall, council appearance.
Your Honor, I apologize. Mr. McCall has private counsel that should be logged in. Would you allow me to email him to make sure he's coming into court?
Yes, because he's not in my virtual courtroom.
Thank you. I'll contact him right now. If you don't mind, if maybe we could do someone else while he's coming in.
No problem.
Thank you.
On the record in the matter, oh, actually, you're gonna email him or call him?
Email him, Your Honor.
Okay, I'll give you a moment.
Thank you. Thank you, Your Honor.
No problem. Okay, on the record in the matter of the people of the state of Michigan versus Charles Dwayne Johnson. Counsel appearance.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Johnson for today's arraignment.
Okay, Mr. Johnson, I have a felony complaint here. It alleges that on or about August 31st, 2024, at Jolly Road at or near Star Avenue, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act of controlled substance possession of cocaine, heroin, or other narcotic less than 25 grams, and that you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine, and that this is contrary to Michigan Compiled Law 333.740328B. That's a felony. It's 4 years and or $25,000 in fines. However, there is an habitual offender fourth offense notice. It says take notice. The defendant has previously been convicted of 3 or more felonies or attempts to commit felonies, and that on or about July 10th, 2002, he was convicted of the offense of larceny from a person in violation of MCL 750.357 in the 30th Circuit Court for Ingham County, State of Michigan, and that on or about December 9, 2004, he was convicted of the offense of home invasion third degree in violation of MCL 750.1104A, A4 in the 30th Circuit Court, Ingham County, State of Michigan, and that on or about March 31st, 2022, he was convicted of the offense of uttering and publishing in violation of Michigan Compiled Law 750.249 in the 9th Circuit Court for Kalamazoo County, State of Michigan. Therefore, the defendant is subject to the penalties provided under MCL 769.12. That would enhance the penalty in count 1 to life if the primary offense has a penalty of 5 years or more, or 15 years if or less if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charge and the maximum penalty attached, as well as the enhancement from the habitual offender notice?
Yes, Your Honor.
Okay, you have the right to be represented by an attorney, and Ms. Sutter is representing you today just for the purpose of your arraignment, but you do have the right to have an attorney represent you at each stage of the criminal prosecution, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. You have the right to remain silent. Anything that you say can be used against you. You have the right to proceed to this matter all the way through to trial. You can plead guilty, not guilty, or stand mute. And so if you stand mute, the matter will continue all the way through to your jury trial. You have the right in this matter to have a preliminary examination, and you have the right to have it within 21 days of today's date, that being the date that you're arraigned. At the time of your preliminary examination, you have the right to require the prosecution meet their burden of establishing sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. If this matter proceeds beyond that examination, The matter will be bound over to the circuit court, or it could remain here on misdemeanor charges. At that time, you would have the right to proceed to a trial, and you have the right again to jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require that the prosecution prove your guilt at a jury trial beyond a reasonable doubt. You have the right to remain silent at your trial and not have silence be used against you. You could waive your silence and testify at your trial if you like. You have the right to subpoena witnesses to testify on your behalf at your trial. And you have the right to see, hear, or question in court any of the witnesses that the prosecution calls to testify against you. Did you understand each of those rights, sir?
Yes, Your Honor.
Is he requesting public defender to represent him?
He is.
The court will enter a plea of not guilty on your behalf. You're currently scheduled for probable cause conference before Judge Cynthia Ward, September 13, 2024 at 9 o'clock in the morning. You have a preliminary examination before Judge Ward in person at the court, September 20th at 8:30 in the morning. Did you get a notice to appear before Judge Ward?
Yes, Your Honor.
What's your home address, sir?
311 Charles Street.
Are you employed?
No, Your Honor.
What's your phone number?
It is 517-703-7016.
Are you currently on probation or on parole?
No, Your Honor.
You can address bond, counsel.
Thank you, Your Honor. I did meet with Mr. Johnson this morning where we did discuss some of the charges here today as well as his history. He did advise me that any violent or assaultive criminal history is a little aged at this point, and I understand that there is no allegations of violence here today. He did not recall any prior failures to appear in court, and he did report to me that he is a longtime resident of the Lansing area. He's lived in Lansing his entire life, and he has significant family and friends in the area. I do understand he's got some criminal history here. Obviously, the habitual offender notice is present here. However, I don't believe he poses a danger to himself or anyone else, nor do I believe in this matter he poses a flight risk. And I would ask the court to consider a personal recognizance bond for him today. Thank you.
Thank you. I don't have any of his information relative to how many times he may have missed court. That wasn't provided to me. However, the statement that he hasn't had any recent violent convictions would not be accurate because there's a 2022 domestic violence third offense that he pled guilty to. In addition to that, I see a drug-related conviction for the last 3 years in a row. So he clearly poses a danger to himself, if nothing else, based on that. Nonetheless, I don't believe personal recognizance bond is appropriate. So bond will be set in the amount of 1,010%. While out on bond, you have the following conditions. I am going to order that you participate in substance abuse testing monitoring while out on bond. And that you're screened for some treatment, both physical, mental, or including substance abuse, and participate in any necessary treatment while out on bond. Do you understand that?
Yes, Your Honor.
You're not to use alcohol, marijuana, or any other controlled substance unless you have a valid prescription. Do you have questions about that?
No, Your Honor.
Where are you not employed, sir?
I lost my job and just haven't had the time to find another one, Your Honor. And I've been helping my mother. My mother is sick.
I'm going to also order that you seek employment while out on bond. You're not to use, purchase, or possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. You need to report to pretrial services within 48 hours of your release. And I'm also going to order random PBT. Do you have any questions? Do you have any questions, Mr. Johnson?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing further. Thank you.
You're all set.
Thank you.
Two.
On the record in the matter, the people of the state of Michigan versus DeMarion Joseph McCall. Counsel, can I have your appearance?
Good morning, Your Honor. William Amadeo, P76194, on behalf of DeMarion McCall. We consent and appreciate getting us in today on Zoom. And DeMarion is up there, Judge. Please state your name, DeMarion, for Your Honor.
How you doing? I'm DeMarion McCall.
Thank you.
Your Honor, I am aware of the charges. I would waive a formal reading and stand mute and argue bond when you deem it appropriate.
Okay. And this is a felony complaint for 2 counts of weapons carrying concealed, maximum penalty 5 years and or $2,500 each count. Your client currently employed?
I know he was in college. DeMarion, are you employed right now?
Yes, I'm supposed to be starting at the Target Distribution Center sometime next week. I don't got the exact
Target
date.
what?
Distribution Center. I don't know how to pronounce it. Distribution. My bad.
You're in school as well?
Yes, ma'am. I plan to go back to LCC.
You plan to go back when?
This upcoming fall.
I thought classes already started.
Yes, they did, ma'am. But I chose to work, and I was working at Meyer for some time. But I have
So you're not going this fall, or you are going this fall?
I am, Your Honor.
Judge, I believe January or December when they start, his grandmother told me he's going to start classes up again. So it'd actually be winter, Judge.
He said this fall, so it's winter semester maybe?
Yes.
Yes, ma'am.
Are you on probation or parole?
Yes, I'm on probation.
Out of which court?
The 54th.
Which judge?
He's actually on probation out of our circuit court, Your Honor, Judge Jamo. He's on height of probation.
Okay. So let's see, this is likely to trigger a probation violation as well.
That is accurate, Judge.
Oh. These are felonies, so you're currently scheduled for probable cause conference before Judge Cynthia Ward. It's going to be on the 13th of September, 8 a.m. You can appear via Zoom or you can appear in person for that. Your preliminary examination is in person before Judge Ward on the 20th of September at 8:30. Do you have any questions about your rights? Because I did not go over those rights. Do you have any questions, sir?
No, Your Honor, I do not.
Okay. The court will enter a plea of not guilty on your behalf. And so he's not requesting court-appointed counsel. He's going to have retained counsel.
That's correct, Judge. I'll be on his case.
You can address bond.
Thank you, Your Honor. He does have retained counsel. He is on height of probation. I got to know DeMarion when he was a high school football player. He was going to play in college. He did hurt his shoulder. We're trying to get him back on the athletic track. He has an amazing support system. His grandmother and grandfather basically raised him along with his mother. He does have retained counsel, as I said. He would have turned himself in. I visited him twice yesterday. He's certainly willing to comply with all rules. I would ask for a PR bond with standard conditions, Judge. Thank you for your consideration.
Okay. A personal recognizance bond would not be appropriate. He's out on, well, he's on probation, so he's already under court supervision when allegedly having these violations and this new charge picked up for 2 counts of carrying a concealed weapon. And the allegations even point to multiple social media posts, which would indicate his possession also of weapons that he would be prohibited from being in possession of. So there's a threat to the public safety. Bond is set at 20,000 cash surety. While out on bond, you have the following conditions. You're not to possess a firearm or any other dangerous weapon. You're to report to all of your future court dates on time. You're not to use, purchase, or possess drugs or alcohol unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You need to report to pretrial services within 48 hours of your release. Do you have any questions about your bond conditions?
No, Your Honor.
Any additional matters for the record, counsel?
No, thank you very much for getting us in today, Judge. Have a good weekend.
Same to you. You're all set, sir. On the record in the matter of the people of the state of Michigan versus Christopher Williams. Our counsel appearance, please.
Good morning, Assistant Public Defender Lauren Sutter on behalf of Mr. Williams.
Are you Christopher, is it Shantuan Williams?
Yeah. Yes.
Okay. Okay, I have a misdemeanor complaint here that alleges that on or about August 30th, 2024, at the area of 5642 Wise Road, City of Lansing, Ingham County, State of Michigan, that you allegedly committed the acts in count 1, 2, and 3 of assault or assault and battery. Count 1 being against a John Eubanks, count 2 against a Jaquay Napier, and count 3 against a Charles Goff, alleging that you did make an assault or assault and battery upon those persons, contrary to MCL 750.811. Each count is a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed if the assault was committed in a place of confinement. Do you understand each count and the maximum penalty?
Yeah.
Is that a yes?
Yeah.
I'm sorry?
Yeah.
Okay. You have the right to be represented by counsel. Ms. Sutter is representing you today for the purposes of your arraignment. You have the right to have an attorney represent you at each court appearance. You have the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have court-appointed counsel represent you. Do you understand your right to counsel?
Yeah.
Okay. He's requesting court-appointed counsel?
He is.
Okay. The court will enter a plea of not guilty on your behalf. You have the right to the presumption of innocence, so that means that you're innocent until proven guilty. You have the right to proceed to trial in this matter, and you have the right to a jury trial. You have the right to see, hear, or question any other witnesses that the prosecutor calls to testify against you at your trial. You can call your own witnesses to trial, or you can present evidence at trial that you think show a defense to these charges. You can remain silent at trial and not have silence be used against you, or you can waive your silence and testify at your trial if you'd like. Do you understand those rights, sir?
Yeah.
Do you have any questions?
Mm.
Are you
Yeah.
employed? You have questions? What's your question?
You know what time to get out?
I don't know if you're getting out yet. Any other questions?
I gotta call. I gave her my mom number. You gotta call her, see?
Your Honor, if I may advise you of something briefly that might be helpful to you. Mr. Williams was found not competent and not restorable last fall. He lives in a group home and has a caseworker.
I was going to order a CATS eval, but you said he was not competent and not restorable last year.
That's correct, Your Honor. I believe it was August 17th of last year was the competency hearing in front of Judge Flores.
Okay. So the 5642 Wise Road is the group home?
And I haven't been able to confirm that for sure. He knows he lives at the group home, couldn't recall the exact address. I reached out to his mother this morning when I was unable to make contact with her. I believe it is, but I can't say for absolutely certain. All of Mr. Goodrich's notes from his representation last year lead me to believe that it is the address for the group home where he resides.
Okay, so let's see here. The affidavit of probable cause would cause me also to believe that this is an incident that occurred in connection to the group home,
Yes.
and that the alleged victims, that's where they reside or work.
Reside or are employed at that location. That's also
Correct.
what I believe.
Okay. Okay, well, under the circumstances, I wouldn't be granting a bond. I don't have a place where I can even release him to because of the alleged victims and the location. I also think that he needs to have an evaluation.
I got my aunt number. I can go over her house Sunday night over there.
Okay, well, I'm gonna remand you for a CATS evaluation prior to your release. In addition to that, we need an address prior to release. I can't rely on you, what your statements are about where you can go. So that individual, that individual, I recognize that you're saying you can, I recognize, sir, that you're saying you can go to your aunt's house, but I can't release you to your aunt's house. Your aunt would need to, have to appear here and advise that she is an appropriate place where you can go. There's a reason why you're housed in a group home. And so I can't just take your word for where you're going to be able to go. Do you understand that?
I can't go back my go home.
Not at this time.
Okay, I can't go somewhere else.
We don't know where you can go right now. However, I think you need to undergo a more recent evaluation before we can determine what's in the best interest prior to releasing you. Okay, sir? So you'll be remanded for now. There is a no contact order that I'm going to put in place, not to be in contact directly or indirectly with John Eubanks, Jaquay Napier, and Charles Goff, not to be wherever they live, work, or go to school.
All right. Thank you.
Any additional matters for the record today, council?
Just, Your Honor, was there a probable cause conference and preliminary examination date for him?
These are misdemeanors.
I'm sorry, pretrial date.
Know that we don't have a generated pretrial date. That will
Understood.
be generated when the court reopens.
Thank you, Your Honor. I have nothing further.
Okay, you're all set, sir.
Did you understand saying? Okay.
On the record in the matter of the people of the state of Michigan versus Ramsey DS. Council appearance.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Mr. Demps for today's arraignment.
Ramsey DS.
How are you doing today, Your Honor?
I'm well, how are you?
As can be.
Okay, I have a misdemeanor complaint that alleges that on or about August 30th, 2024 at the area of 3606 West Miller Road, City of Lansing, Ingham County, State of Michigan, you allegedly committed the act in count 1 of domestic violence. The allegation are that you did make an assault or assault and battery upon a Lorena Lambert Romero, an individual with whom you had a dating relationship, and that this is contrary to Michigan Compiled Law 750.812. It's a misdemeanor. The maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the offense was committed in a place of confinement. You understand the charge and the maximum penalty, sir?
Yes, Your Honor.
Okay. You have the right to be represented by an attorney. Ms. Sutter is representing you today so that you can be arraigned, but you do have the right to have an attorney represent you at each stage of the criminal prosecution. You have the right to have an attorney represent you if you're questioned by law enforcement. And if you can't afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. You understand your right to counsel, sir?
Yes, I do, Your Honor. Thank you so much.
You're no problem. You have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to plead guilty, not guilty, or stand mute. If you stand mute, the matter will continue all the way to a jury trial. At the time of trial, you have the right to require the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to confront in court any of your accusers and question any witness called to testify against you. You have the right to subpoena your own witnesses to testify on your behalf at your trial, and you have the right to waive your silence and testify at trial, or you can invoke your right to silence and not have that silence be used against you. Do you have any questions about those rights?
No, Your Honor.
You're currently scheduled for a pretrial conference. It's going to be before Judge Anthony Flores. It's going to be September 23rd, 9 o'clock in the morning. You can appear in person or by Zoom for that, okay?
Yes, Your Honor.
Did you get your notice to appear?
Yes, I did.
Okay. Is he requesting court appointed counsel?
He is.
I'll note that as well as enter a plea of not guilty on your behalf. Are you employed?
No, ma'am, I am employed.
You're unemployed?
No, Your Honor, I am employed.
Okay, where are you employed? I asked where you're employed. Where are you employed?
I manage at Wendy's,
Which Wendy's?
downtown.
Oh. Your address is the address.
413, I believe.
No, what is your
Kalamazoo?
home address?
Oh,
What
my
is your home
address.
address?
4245 West Jolly Road, lot 211.
And that's not the address of Miss Lambert Romero, correct?
What did you say, Your Honor? I didn't quite hear you.
Miss Lorena Lambert Romero does not live at that address with you, correct?
Oh, Your Honor.
Can you repeat
She
that
has in
because
the
it didn't
past,
come?
She
Okay,
has in the past, but not currently, no.
okay, thank you. And your phone number?
It's the phone that I was booked by, but I don't have the number currently right now. It's a new phone, Your Honor.
Okay.
He did provide me an email address, Your Honor, this morning.
What's his email address?
It's his first name, his last name, the number 2@gmail.com.
You're not on probation or parole, correct?
No, Your Honor.
Have you missed court in the past?
I'm sorry, I didn't quite hear what you said.
Have you missed court in the past?
Court dates, yes.
You've missed court dates, why?
Work. There were strict
So you need-
attendance. I'm so sorry for cutting you off.
No problem. I think there's a little bit of a delay in our connection. So you knew you had court and you didn't go because you had work?
Yeah, because I had rent due that exact month and I needed those days to actually not be homeless on that exact month. But the attendance at the factory, I worked at that time, I worked at Gestamp and Mason, which is also where I got the prior ticket. We're also they had attendance issues and they didn't want anyone to miss them for any reason whatsoever. And so I had to go in to also make that money.
And then what did you do after you missed your court date?
I tried following up with not this court, but the Mason 54 district court to check on my well, it's now a bench warrant, but I didn't know it was a warrant at the time and I was unaware of those dates until I again said that I had work and couldn't make them.
And Your Honor,
I believe
So you currently have a bench warrant in Mason?
I believe so.
and Your Honor, I did look up that earlier. It was a show cause hearing he missed for a collections issue.
You can address bond.
Thank you, Your Honor. I did meet with Mr. Demps this morning to discuss some of the situation going on here. As I just noted for the court, he did advise me he became aware of the bench warrant in 55th District Court for a missed show cause hearing in front of that court for a collections payment that he's been working on. He did advise me outside of that, he could not recall any prior failures to appear in court. And he did advise me that he has no prior violent criminal convictions on his history. I do understand the seriousness of the allegation here. However, I do believe with the no contact order that he and I went over in depth this morning, that his history does not indicate he is a danger to himself or the community. He is employed full-time in the city of Lansing. He has a management position, as he said, at the Wendy's downtown. And I do not believe he poses a further flight risk in this matter. And I would ask the court to consider a personal recognizance bond on his behalf today. Thank you.
Well, I don't know, I was gonna give him a PR bond, but what if he has to work and then he just doesn't come to court? Because it doesn't sound like he makes adequate effort to follow up. If there's some reason why your job, which I find it unreasonable that if you told your job you had court that they wouldn't understand that that's not a negotiation. However, I believe that it's your responsibility once you miss it to get your behind to court and get it taken care of.
Yes, Your Honor.
So you're not surprised that you had a bench warrant and you didn't do it. That's my concern.
Well, no, it's not. I wasn't surprised necessarily. The fact is that I didn't necessarily have the financials to do it. And then when they were notifying me at the time, I had another phone. It was through my brother, and then this phone is through mine. So there was a little translation through electronics. And I didn't probably quite get that notice at that time.
Well, you told me you missed court because you had to work.
Yes, but that is again my fault.
What if you have to work when you're supposed to be before Judge Flores on the 23rd? What are you gonna do?
Well, I have a very good rapport with my general manager currently at Wendy's, so he understands those situations that I have to go through. So that wouldn't be a problem in this situation.
Bond is set in the amount of 500 personal recognizance bond with the no contact order in place for the protection of a Lorena Lambert Romero. You're not to have contact directly or indirectly with her. That means you can't communicate or have anybody else communicate with her for you. You're not to be within 1,500 feet of wherever she is.
Yes,
Do you
Your
have
Honor.
any questions? You need to appear for all of your court dates. You are not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess drugs or alcohol without a valid prescription. And you're not to possess a firearm or any other dangerous weapon. Do you have any questions today, sir, about your bond or anything else?
One question, ma'am. So I'm not allowed to consume recreational marijuana?
You're not to have drugs or alcohol unless you have a valid prescription. That includes marijuana.
Okay. Yes, Your Honor.
Any other questions?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing further. Thank you.
Thank you. You're all set. On the record, in the matter of the people of the state of Michigan versus Tran Malik Hersey. Counsel appearance, please.
Good morning, Assistant Public Defender Lauren, or good afternoon, Assistant Public Defender Lauren Sutter on behalf of Mr. Hersey for today's arraignment.
You're Tran Hersey.
Yes, ma'am. Yes, Your Honor.
Okay, Mr. Hersey, I have here a misdemeanor complaint alleging that on or about August 30th, 2024, at 400 South Fairview, City of Lansing, Ingham County, State of Michigan, you allegedly committed the act of domestic violence. The allegation is that you made an assault or assault and battery upon a Shamron Thornton, an individual with whom you had a child in common, or a resident or former resident of your household, or an individual with whom you had a dating relationship, in contrary to Michigan Compile Law 750.812. That's a misdemeanor with a maximum penalty 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charge and the maximum penalty?
Your Honor.
Okay. You have the right to be represented by an attorney, and Ms. Sutter is representing you today to be arraigned. You have the right to be represented by an attorney at every court appearance and if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. You understand your right to counsel?
Yes, Your Honor.
You have the right to remain silent. Anything that you say can be used against you. Anything you put in writing can be used against you. You have the right to plead guilty, or you can plead not guilty, or you can stand mute. If you stand mute, this matter will proceed all the way to a jury trial. And you have the right to a jury trial. At the time of your trial, you have the right to the presumption of innocence. You're innocent until proven guilty. And you have the right to require that the prosecution prove each element of the charge of domestic violence beyond a reasonable doubt at your trial. You have the right to remain silent at trial and not have the silence be used against you. You can waive your silence and testify if you'd like at your trial. You have the right to subpoena witnesses to trial that would testify for you. And you have the right to see, hear, or question any other witnesses the prosecution calls to testify at your trial. Do you have any question about those rights?
No, ma'am.
You're currently scheduled. Thank you. You're currently scheduled for pretrial conference before Judge Stacia Buchanan. It's going to be September 16th, 2024 at 9:30 in the morning. Did you get a notice to appear before Judge Buchanan?
Yes, Your Honor.
Are you currently employed?
No, ma'am. No, Your Honor. I'm currently working on self-employment. I just ordered a package for, basically I'm trying to do resale and stuff like that. So I'm currently waiting on a package right now just to see how that whole operation is gonna go.
Is he requesting court-appointed counsel?
He is.
Okay, I'll enter a plea of not guilty on your behalf and note that you are requesting the public defender's office to represent you. What's your home address?
400 South Fairview Ave, Lansing, Michigan, 48912.
Okay, well, Ms. Thornton lives there, so you won't be able to live there.
I'm
Where are you
aware of
gonna
that.
stay?
Like I told the attorney, I have a couple different places I can go. It's just that I will have to call and see which one that I can exactly stay at to provide you guys the address. But I know for a fact I have a couple different places to go to.
Your Honor, his brother and his sister both have homes in the city. He would just need to get the address from them.
What's your phone number?
517-221-9878.
Are you currently on probation or on parole?
No, Your Honor.
Have you missed court before?
No, Your Honor.
You can address bond counsel.
Thank you, Your Honor. I met with Mr. Hersey this morning where we had a brief discussion regarding his situation. As he's told the court, while he doesn't have a full-time employment right now, he is working on getting his own business off the ground. And to that end, he has been making some steps forward towards starting that business. He also did advise me that he's a lifetime resident of the Lansing area and his entire family resides locally. He has been staying with his sister and he does have other siblings in the city whom he intends to stay with and would be able to provide the address to the court to as soon as he is released. He did also advise me, as he's told the court, he had no prior failures to appear in court that he could recall and no prior no prior violent or assaultive criminal convictions. I do believe, Your Honor, with appropriate bond conditions like the no contact order that he and I discussed in depth this morning, that he does not pose a danger to himself or the community, nor does he pose a flight risk. And I would ask the court to consider a personal recognizance bond for him today. Thank you.
My understanding of this, there is a PPO on this.
He advised me that LPD told him about that when they took him into custody. He did not appear to be aware of it before that.
And I do see in 2021, there was a guilty plea to a domestic violence PPO order.
That should have got
Mr.
dropped.
Hersey, I'm gonna advise you not to talk on that.
Okay.
I don't see any other violent convictions, but I see where he was charged with several other violent convictions in the past. So that is a concern. However, I think a no contact order would be sufficient for the protection of the alleged victim in this matter. Shamron Throton, you're not to have contact directly or indirectly with her. Do you understand that?
Yes, Your Honor.
You're not to be within 1,500 feet of wherever she is, and you're not to have anybody make contact with her on your behalf. Do you understand that?
Yes, Your Honor.
Bond is set at $500 personal recognizance. You must appear for all of your court dates. You need to provide the court with a valid address no later than 8 o'clock in the morning this Tuesday, which is going to be September 3rd. Do you understand that?
Yes, Your Honor.
And, Your Honor, I apologize. 8 a.m. on Tuesday?
8 a.m. on Tuesday. He needs
is
to
the court
provide the
gonna
court
be-
with it.
I apologize. I'm just trying to determine, is the court going to be open and available for him to make that report before 8 a.m. on Tuesday?
The court opens at 8 a.m. on Tuesday. We're going to be closed on Monday. So that's why I said 8 a.m. on Tuesday. The court will be open at 8 a.m. on Tuesday. Also, while out on bond, you're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state unless you have prior approval from this court. Do you have any questions about your bond conditions?
No, Your Honor. Well, I do have one thing, because I share a kid with this person. So how would I just have to go to the court and try to get some type of custody, like partial custody or something?
Yeah, you need to go to the family court for that and deal with that. You could probably do that, and you're gonna be around, you're gonna be over here at 8 o'clock in the morning on Tuesday giving us your address, so you could probably walk on over to the family court after that, okay?
Yes.
Do you have any questions?
No, Your Honor.
Okay. Any additional matters for the record?
Yeah, just if you wouldn't mind spelling the complaining witness's name so I can do our conflict check.
I have it spelled as SHAMRYN, and then last name Throton, THRONTON. I don't know if those are typos though. That's just what I have.
Understood. Thank you. I appreciate it.
Okay, thank you. Any additional matters for today's record?
Nothing further. Thank you.
you're all set for today, Mr. Hersey.
Thank you, Your Honor. Thanks.
On the record in the matter of the people of the state of Michigan versus Edward Dion Westbrook, file. I have two files. Let's see if this one has a file number. There's a new file and then file number 22-03208, counsel appearance.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Westbrook's
Edward.
arraignment.
Yeah, it's your turn. Yeah. Step bring all of it to the table.
Are you sleeping, sir?
Yes, ma'am.
Okay, do you need a moment to wake up?
I'm up now, ma'am.
Okay, I have a fresh file that you need to be arraigned on. And then it looks like you have an older file that needs to be addressed. I have a felony complaint here that alleges that on or about August 31st, 2024, at the area of 601 North Lark Street, City of Lansing, Ingham County, State of Michigan, you allegedly committed the act of controlled substance possession of methamphetamine or ecstasy, and that you did knowingly or intentionally possess methamphetamine contrary to Michigan Compiled Law 333.74032 BI. That's a felony. Maximum penalty is 10 years and or $15,000 in fines. However, there's an habitual offender second offense notice. Says take notice that the defendant was previously convicted of a felony or an attempt to commit a felony, and that on or about January 14th, 2008. He was convicted of the offense of computers used to commit a crime more than 4 years or less than 10 years in violation of MCL 752.7973D in the Ninth Circuit Court for Kalamazoo County, State of Michigan. Therefore, the defendant is subject to the penalties provided by MCL 769.10. That makes your maximum sentence 1 1/2 times the maximum sentence on the primary offense or lesser term. The maximum penalty cannot be less than the maximum term for a first conviction. Do you understand the charge and the maximum penalty, including the habitual offender second offense notice, which would enhance your maximum penalty?
Yes, ma'am.
Let's see what is going on in this file. And file number 22-03208. It looks like there was an indication that you failed to appear for arraignment on a retail fraud in the 3rd degree. So there's a misdemeanor complaint in this file that alleges that on or about March 4th, 2022, you did allegedly commit the act in count 1 of retail fraud 3rd degree, and that you did while Speedway was open to the public, still property of the store that was offered for sale at a price less than $200, contrary to MCL 570.356D4. And that's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, or 3 times the value or difference in the price of the property stolen, obtained, or attempted to be obtained, whichever is greater. And this is allegedly having occurred at the address of 3201 East Saginaw, City of Lansing, Ingham County, a state of Michigan. You understand the charge and the maximum penalty there, sir?
Yes, ma'am.
Okay. You have the right in both files to be represented by counsel, and Ms. Sutter is representing you for your arraignment today only, but you have the right to have an attorney represent you at each stage of the criminal prosecution on these files. You have the right to be represented by an attorney if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed to represent you. You understand that, right, sir?
Yes, ma'am.
You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. In the felony file, you have the right to a preliminary examination. You have the right to have that within 21 days of today's date, because today's the date you're being arraigned. At the time of your preliminary examination on that felony, you have the right to have the prosecution put forth evidence that would suffice probable cause sufficient to charge you with the crime, and probable cause sufficient that there was a crime committed. You understand that?
Yes, ma'am.
You have the right on both matters to proceed to jury trial. In each file, you have the right to the presumption of innocence. So that means, sir, that you're innocent until proven guilty, and you can require the prosecutor to prove your guilt in each of these files. They would have to prove each element of each of the charges being brought against you beyond a reasonable doubt. You can remain silent at your trial and not have silence be used against you. You can waive silence and testify at your trials if you'd like. You have the right to subpoena witnesses to your trial that would testify for you. And you have the right to present evidence that you believe show a defense to the charges being brought against you. You also have the right to see, hear, or question any other witnesses called to testify against you. You understand that?
Yes, ma'am.
Do you have any questions about your rights?
No, ma'am.
Okay, let's see. And the felony file, you're currently scheduled for probable cause conference before me, Judge Kristen Simmons. It's going to be September 13th, 2024 at 8:30 in the morning. You have a preliminary examination scheduled September 20th at 9 a.m. Did you get your notice to appear for that?
Yes, ma'am.
Okay, and then in the misdemeanor file, that matter has not been reset for a pretrial. I'm inclined to believe at this point that it would be set for before me, but you'll get that in the mail, okay?
Yes, ma'am.
What's your home address?
1513, apartment 1, Kalamazoo, 1513 Kalamazoo, apartment 1. East Kalamazoo, apartment 1.
It's East Kalamazoo, not West?
No, ma'am, it's East Kalamazoo.
Okay,
East Kalamazoo Street.
thank you. What's your phone number?
517-528-8604.
Are you employed?
Not at the moment, ma'am.
Is he requesting court-appointed counsel, Ms. Sutter?
He is.
The court will enter a plea of not guilty on your behalf on both files. Okay, let's see. Are you currently on probation or on parole?
No, ma'am.
Let's see. School history. Have you missed court in the past?
Ma'am,
It didn't pick up your response. Can you repeat it?
you said, have I been in your court in the past?
No, I said, have you missed court?
I was incarcerated when I did. That's the only reason why I missed it, ma'am.
Okay. The court's gonna enter a plea of not guilty again on both files. Note that you're requesting court-appointed counsel. What address do they have on this one? That might be right, Mr. Raymond. You can address bond counsel.
Thank you, Your Honor. I did meet with Mr. Westbrook this morning to discuss some of his situation with him. He did advise me that he's been living in the Lansing area for the past 6 years with plans to remain here. He did advise me that he believes he changed addresses in the last couple of years, so that may be part of the non-appearance in the older file here. While he is not currently employed, he did advise me, as he's told the court, that he does not recall any prior failures to appear in court. There are no allegations of violence here, and any violent criminal convictions he does have are several years old. I do not believe in this matter that he poses a danger to himself or the community, nor do I believe he poses a flight risk, and I would ask the court to consider a personal recognizance bond for him today. Thank you.
A bond will be set in the amount of 2,500 personal recognizance on the felony file. You have the following bond conditions. You're not to use, purchase, or possess a firearm or any other dangerous weapon. And you're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You are required to report to pretrial services within 48 hours of your release.
Yes, ma'am.
The misdemeanor file will have your address properly updated. You need to make sure that the court is updated with any future changes in your address, okay?
Yes, ma'am.
Bond is set in the amount of 500 personal recognizance on that file. Same bond conditions. No travel outside the state. You're not to possess a firearm, no drugs or alcohol without a valid prescription. And report to all of your court dates on time. I'm also going to require that you not enter the speedway at the address of 3201 East Saginaw. Do you have any questions?
No, ma'am.
Yes.
Any additional matters for the record, counsel?
Nothing further. Thank you.
Thank you. You're all set.
Hey, you can come.
Yeah.
What are you doing?
Okay, on the record in the matters of the people of the state of Michigan versus Aquarius, DeMarion Bradford. I have file number 24-02442. And then I have file number 24-01131. Council appearance, please.
Good afternoon. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Bradford for today's arraignment.
Okay. Mr. Is it Aquarius Bradford?
Yes, ma'am.
Okay, I have two files for you. File number 24-01134. It's a misdemeanor complaint that alleges that on or about August 21st, 2023, at the area of 3210 Turner Road, City of Lansing, Ingham County, State of Michigan, you allegedly committed the act of domestic violence by allegedly making an assault or assault and battery upon a Tashana Hawkins, an individual with whom you had a dating relationship contrary to MCL 750.812. It says here restitution may be ordered as this offense may have resulted in damage to another individual's property or death to another individual or physical injury under MCL 780.811. It's a misdemeanor. Maximum penalty is 93 days and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. File number 24-02442FY. I have a felony complaint. It alleges that on or about July 10th, 2024, at the area of 3210 Turner Street, Apartment D, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act in count 1 of interfering with a crime report, committing a crime threatening to kill or injure. Allegations are that you did, through the unlawful use of physical force, prevent or attempt to prevent another person from reporting a crime committed or attempted by another person, and the violation involved committing or attempting to commit interfering with electronic communications against a person or threatening to kill or injure a person contrary to MCL 750.84332B. It's a felony with a maximum penalty of 10 years and or $20,000 in fines, and a consecutive sentence may be imposed for any other conviction. There's a count 2 of assault with a dangerous weapon. That's also called a felonious assault. The allegations are that you made an assault upon a Tashana Hawkins with a dangerous weapon, that being a shotgun, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. That's a felony with a maximum penalty of 4 years and or $2,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 3 is weapons felony firearm. The allegations are that you did carry or have in your possession a firearm, that being a shotgun, at the time that you committed or attempted to commit the felony of assault with a dangerous weapon, contrary to MCL 750.227B. That's a felony with the maximum penalty of 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, and there's a mandatory forfeiture of the weapon or device required under the law. Count 4, interfering with electronic communication, alleges that you did willfully and maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication by or through a telephone or telephone line, contrary to MCL 750.5405A. That's a felony, maximum penalty 2 years and or $1,000 in fines. Lastly, count 5, domestic violence alleges that you did make an assault or assault and battery upon a Tashana Hawkins, an individual with whom you had a dating relationship, and this is contrary to MCL 750.812. That's a misdemeanor, maximum penalty 93 days in jail and or $500 in fines. Do you have any questions about any of the charges or the maximum penalties on each?
No, ma'am.
You have the right to be represented by an attorney at every court appearance on each of these files. Ms. Sutter is going to represent you today for your arraignment. You also have the right to be represented by counsel if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. Are you all right? Wear your hands on your head.
Oh, sorry.
Is he requesting court-appointed counsel on these files?
He is.
Okay, the court will enter a plea of not guilty on your behalf on each file. The felony file, sir, you have the right to a preliminary examination within 21 days of today's date, because that's the date that you're being arraigned on this file. You're currently scheduled for probable cause conference before Judge Cynthia Ward, September 13th at 8 o'clock in the morning. You have a preliminary examination before Judge Ward in person at the court, September 20th at 8:30 in the morning. Did you get a notice to appear?
Yes, ma'am.
At the time of your preliminary examination, you have the right to require the prosecution to put forth evidence that would establish they have sufficient probable cause that a crime was committed and sufficient probable cause to charge you with the crime. Again, you have the right to have that exam within 21 days unless you waive that timeline or unless the court finds good cause to go beyond the 21 days. In both files, you have the right to trial and the right to jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any other witnesses called to testify against you at your trial. You have the right to remain silent at trial and not have silence be used against you, or you can waive your silence and testify at your trial if you like. And you have the right to subpoena witnesses to trial that will testify on your behalf. Do you have any questions about those rights, sir?
No, ma'am.
Are you currently employed?
Yes, ma'am.
Where?
At Ryder.
How do you spell that?
RYDER.
Oh, you're employed at Ryder, you said? Not, I thought you
Yes,
said
ma'am.
at Ryder. What do
Yes,
you do
ma'am.
there?
Material handle.
Are you currently on probation or on parole?
No, ma'am.
Where are you gonna reside? Because you won't be able to reside at the 3210 Turner Street Avenue or address.
1141 Dorchester. That's my address.
Repeat that for me.
1141 Dorchester.
Is there an apartment at all?
Yes, ma'am. Apartment 10.
What's your phone number?
517-894-1573.
Okay, in the misdemeanor file, you have a pretrial schedule before Judge Cynthia Ward, September 17th at 10 o'clock in the morning. So you should have received notices to appear for both files, correct?
Yes, ma'am.
You can address bond counsel.
Thank you, Your Honor. I did meet with Mr. Bradford this morning. He did advise me that he's a longtime resident of Lansing area. He's lived here for the past 8 years and he does have family and friends nearby. He also advised me he does have an address away from the complaining witness here. He could not recall any prior failures to appear in court. I did advise him that there would be a no contact order here and discuss with him the seriousness of that no contact order. I would ask the court to consider a personal recognizance bond here for him today. I believe with appropriate bond conditions that he does not pose further risk to himself or the community, nor does he pose a flight risk in this matter. Thank you.
Okay, let's see. Notice that there's the same victim on both files. Let's see. I don't see any previous convictions. However, I do see another domestic violence that was charged last year in Nolly. And then again, the allegations in both files are that these are the same victims. GPS tether will be ordered. I will grant personal recognizance bond. On the misdemeanor file, bond is 1,500 personal recognizance with GPS tether. And on the felony, a bond is set at 5,000 personal recognizance with GPS tether. You're not to have contact directly or indirectly with Tashana Hawkins. Do you understand that?
Yes, ma'am.
It means you can't speak to her. You can't cause anybody else to speak to her on your behalf. You're not to be within 1,500 feet of wherever she is. Do you have any questions about that?
No, ma'am.
You're not to be at the address of 3210 Turner Apartment D. You are to report to pretrial services within 48 hours of your release regarding the felony matter. In both matters, you're not to possess a firearm or any other dangerous weapon. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You're not to travel outside the state without prior approval of the court.
You said no
Yeah,
marijuana?
No marijuana unless you have a
Okay.
valid prescription. And then you need to show your valid prescription to the court first, but no marijuana or alcohol without a valid prescription. Do you have any other questions, sir?
Oh, ma'am.
Very good. Any additional matters for the record, counsel?
Nothing further. Thank you.
You are all set.
Thank you.
Thank you. I think that was all the files I have for today.
I think so. Thank you, Your Honor. I'll see you tomorrow morning.
Thank you. Have a good one.